Okay, yes, again, thank you. Good afternoon to everyone. I'd like to start. We have a quorum. The adoption of the minutes, the meeting held on November 18th, 2020. If someone, I know if I know you had a chance to review the minutes. Any additions or corrections? And if not, I just need a motion to accept the minutes of November 18th, 2020, and a second.
So moved.
Make a motion, no second.
Properly moved and seconded. Any questions? All in favor? Just put your thumbs up there, and all in favor. Any opposed? The motion carries. Thank you so much. There's going to be Jake. You did a good job on the putting all that information from all the different meetings. So we're going to have a discussion on the draft report and the recommendations. And I think we'll go right to the recommendations. I think what we're trying to do here.
Great.
Is
hold on one second. Let me get to a quieter room.
The original resolution. The original resolution, we're to provide recommendations on policies pertaining to the Rhode Island Law Enforcement Bill of Rights. So that was our charge in the resolution. That was our charge in the resolution. But certainly, as we heard from various members on both sides, and certainly from the community, we came up with a lot more recommendations, and we certainly want to include that in the report. But I think we, in the framework of that, Jake put together the recommendations. Now, I think what we want to do is, if nothing else, I think we know that the objective is to have a system that's honest, that's balanced, that has credibility, and enhances the trust that we want to build. And so I think the objective is really clear. Now the methods on how we get there, this is what we're going to do as we go through these recommendations. And number one, if you have your recommendations with you, I don't want to get bogged down so much as to the number of days, but I think we need to find common ground as so the first one is extending the summary discipline period beyond the 2 days. Now, the Rhode Island Police Chiefs Association recommends extending summary discipline period up to 10 days. The Rhode Island League of Cities and Towns recommends extended summary discipline up to 10 days. In a written correspondence, IBPO supports extending summary discipline period up to 5 days. And House Bill 8036 proposes summary discipline period for up to 30 days. And this proposal was mentioned by Mr. Ragasta in his testimony. So let's begin there with extending the summary discipline period beyond 2 days. And from what I can remember, most people were in agreement. We never settled in on the number of days as a commission, the task force. But I think there was a consensus about that we need to extend this summary discipline period. And we'll open up the floor for discussion with that.
This is Jim Vincent of the NAACP. Can you hear me?
Yes.
Okay. Well, I've taken a look at everything, and in looking at days, I'm in agreement with Representative Anastasia Williams. I think it should be 30 days. And I just think that in days gone by, maybe chiefs use their power. I know the chiefs of today, and the chiefs that I know today throughout the city are all professional, and they're the kind of people that I feel are fair. And I think what's happened is that it's gone too far away from the chiefs in terms of their power, and I think anything less than 30 days for me is a problem.
Senator Rogers.
How you doing, Senator?
Good thing.
I'm comfortable with the 10, and hold on. And the reason why I say the 10 is once you get into the 30 days, I mean, that's grievous enough. We're probably looking at termination. So I don't want to pick it apart here, but I think when you're at the point of 10 days, anything further than that, it's something more serious, and they're probably going to be looking at termination. So I think the 10 days is much more than the 2, and I would be comfortable with the 10. I'm not going to say get into some police chiefs that, you know, I've worked in cities and towns, and, you know, I just want to say I think 10 is more than sufficient. I'll just stand on that.
Anyone else? Yes, Chief Clements, and then Mr. Cabazon.
If I may, Mr. Chairman, so I'll piggyback on Senator Rogers' comment with agreeing in imposing the increase to 10 days. And I think the testimony has been borne out in these hearings in that the practitioners of the LEOBoR have shown that exactly what Senator Rogers said. When you're looking at 10 days or more, there's almost grounds for a lengthy punishment of termination. And even if you're looking at 3 months, 6 months, or a year, we're getting those penalties. And I've testified to that, you know, aside from LEOBoR hearings, we've had those 27 cases in the last 9 years where guys have been forced to resign or terminated with the Bill of Rights in play. So 10 days, I think there is a need and a call for more days, and that 2 to 10, I think, suffices for our purpose. And that was the resounding voice I heard on the police chief side with the survey and both in conversations on the side with separate committees.
Yes, Tony, excuse me, Mr. Cabazon.
Tony, you're muted.
Can you hear me now?
Yes.
I believe the 10 days is excessive. And the reason why I believe it's excessive is because right now with the 2 days, when you look at the statute reads that summary punishment of 2 days may be imposed for minor violations of the fundamental rules. So we're only talking about minor violations. You know, not wearing a hat could be a minor violation. But more importantly, we've heard time and time again the cost involved in the Bill of Rights. Well, right now, most officers that get the 2 days accept the 2 days. And you can tell by the surveys that were done that in 5 years there's only been 4 hearings. By increasing it to 10 days, I think there would be very few officers that would not grieve the 10-day suspension. And that's counterproductive of what we're doing when it comes to finances. The other reason is, again, we're talking about very minor departmental violations. And I've mentioned this once before. You're talking 10 days. With some departments, we're talking a $3,500 violation, penalty for a very minor violation. And even for one of the least paid departments, which is Block Island, it's a $2,500 penalty that they would be getting. Now, the purpose of the 2 days is really supposed to be corrective. When you get into penalties and that amount of money, it's no longer corrective, it's punitive. And I think you're going to see a lot more appeals to a 10-day suspension. My organization recommended 5. Even at 5 days, the penalties are still going to be rather high. Again, you're talking 5 days on the highest paid department would be $1,700. So, I think even that might increase hearings, but, or arbitrations, I should say. But those are the main reasons why I would object to the 10 days. So.
Anyone else?
Yes, if I, can I be heard?
Yes, Mike, go ahead.
Okay. My perspective is this, that there's been so much conversation in the past few meetings about the low number of cases that have actually proceeded to hearing within the past few years, but I've always cautioned that that statistic needs to be looked at in the proper context, and I believe it was Sid Wardell who responded to a question of mine at the August meeting when I asked if, in fact, the discipline that was being meted out by police chiefs was impacted in any way by LEOBoR. He did say that his survey of police chiefs revealed that police chiefs actually did a cost-benefit analysis, and that would affect the decision as to how many days they would impose. So I think we need to look at the number of days or the number of hearings in that context, because otherwise I believe we're doing ourselves a disservice as a task force. But I personally support Jim Vincent's recommendation of 30 days.
Anyone else? Anyone else? Well,
Senator, I think Elise Swearingen had her hand up, and at this point, it's probably worth noting for the record that Ms. Swearingen contacted the commission last week to inform us that the para board chair had requested that, and de facto appointed her to sit in Mr. Batista's place after the events of 3 weeks ago.
yes, Ms. Swearingen. Thank you. Sorry about missing it. It's okay.
You're totally fine. I only have a question about clarification. So is it either 2, 5, or 30, or is it up to 30 days? So the police chief would have the autonomy to decide if it's 5 days, 10 days, or 30 days.
Well, I based on what we've covered, I imagine it could be up to 30 days. But if someone else could help me out with that.
Senator, yeah, that's correct. If it were the new wording in the statute, that would be up to 30 days. So anywhere from 1 to 30 days, correct?
If I can, just maybe to shed some clarification, I think right now LEOBoR provides that a chief can impose up to 2 days without triggering LEOBoR, and then the other suggestions are up to 5 days, or up to 10 days, or up to 30 days, imposing, for example, a suspension without triggering LEOBoR and the rights that come with commission staff.
And I don't understand why it could not be more than 30 days. If somebody wanted 40 days, what would prohibit that recommendation of 40 days? I don't understand why it can't be 40 days.
And the answer is it can, Jimmy. And we've had several forms of discipline where it's been 3 months, 6 months, up to a year. We haven't gone over a year. I mean, once you're in that, as Senator Rogers identifies, once you're over 10 days, it becomes a calculated risk of you probably have enough for a severe penalty, and it's a balance. It's like a court hearing, like, what do we have enough to prove here? But to answer your question, it can be 40 days. It can be.
I understand the risk, but somebody might feel that the risk is worth for 40 days. In their mind, it's better for 40, and they're willing to take that. That's all I'm saying.
That's right. That's correct.
Okay, thank you.
Any further discussion? Is it okay if we know everyone's preference that you just presented in the record, and then at least take a vote that we need to to increase the summary discipline beyond the 2 days. No, no fewer than 5, but I at least want that noted in the record, and then we can put how everybody felt on about that.
Well, could I recommend a different approach, which is, because I think this report it needs to be more particular. And so my suggestion would be that we entertain a motion starting at 30 and going down and survey the board to see what their votes are. There may be 1 or 2 people who are in favor of 30, in which case that wouldn't carry. We could move down to 10, but I personally would like to see a recommended number of days. I think that giving the legislature more guidance is better, is preferred.
And if it's okay with you, in terms of what you just said, in terms of Mr. Iwara, I'd like to make the motion for 30 days.
I second that.
It's been moved and seconded for 30 days. Any questions? Yes, Reverend Washington Nelson, excuse me. Chantel? Oh, I'm sorry.
I didn't have a question. I was ready for the vote. Sorry.
Okay. All in favor of the motion for the 30 days, give me the thumbs up. Those opposed? What do we have there, Jake?
Senator, the motion, it may be easier to do this on a roll call vote rather than me looking at the screen.
Okay.
However,
Yeah, do it. Go ahead. You proceed.
All right. On a motion made by Mr. Vincent and I believe seconded by Mr. LEOBoR, the recommendation would be that summary discipline period be extended to 30 days. I'll start with the roll. Senator Metz?
Yes.
Senator Coyne? Senator Coyne, no. Senator Rogers?
No.
Senator Rogers, no. Attorney General Nerona?
No, but we didn't get a chance, frankly, as Senator Metz said, before we called this vote, to say whether we were in favor of increasing the number. I just want to put on the record that I am. The key, of course, is in the detail of what number. So I'm going to take that opportunity now, since I haven't had it already. In my experience is born of this, that when I was U.S. Attorney, the number for us was 14 days. If we were going beyond 14 days, we moved immediately to dismissal. And so I understand, I certainly believe more than 2 days is appropriate. I also understand that going out too far, in a sense, is not necessarily going to be the kind of tool a police chief is often going to use. So on this particular number, 30 days, I vote no, but I do believe that the number should be extended.
Mr. Iwara?
Yes.
Yes,
LEOBoR votes yes. Mr. Vincent?
Yes.
Mr. Vincent votes yes. Mr. Capezza?
No.
Mr. Capezza votes no. Ms. Swearingen?
Yes.
Ms. Swearingen votes yes. Reverend Washington?
Yes.
Reverend Washington votes yes. Colonel Clements?
No on 30.
Colonel Clements votes no on 30. For the record, Colonel Manny, Ms. Bettencourt, and Reverend Jenkins are shown as absent. The motion fails on a vote of 5 to 5.
I'd like to make on that.
I'm sorry, what was that, Mr. Vincent?
We have to go to 14 days.
Mr. Vincent makes a motion to extend to 14 days.
Is there a second?
Seconded.
Seconded by Ms. Swearingen.
Any questions? Well, take the roll call again. We'll take the vote.
All right. On extending summary discipline to 14 days on a motion made by Mr. Vincent and seconded by Ms. Swearingen, Senator Metz.
Yes.
Senator Metz votes yes. Senator Coyne.
No.
Senator Coyne votes no. Senator Rogers.
No.
Senator Rogers votes no. Attorney General Nerona. Attorney General Nerona votes yes. Colonel Clements.
No.
Colonel Clements votes no. Mr. LEOBoR.
Yes.
Mr. LEOBoR votes yes. Mr. Vincent.
Yes.
Mr. Vincent votes yes. Mr. Capezza.
No.
Mr. Capezza votes no. Ms. Swearingen. Ms. Swearingen votes yes. Reverend Washington.
Yes.
Reverend Washington votes yes. For the record, Reverend Jenkins, Colonel Maney, and Ms. Betancourt still shown as absent. On a vote of 6-4, that motion carries.
Okay, thank you. Recommendation number 2, changing and/or expanding the composition of the hearing panel. The Rhode Island Police Chiefs, the Rhode Island Police Chiefs. Yes, who's that? Okay, the Rhode Island Police Chiefs Association recommends expanding the hearing panel to 5 members, with the majority of the members having a background in law enforcement. The Rhode Island League of Cities and Towns recommends expanding the composition of the hearing panel to 5 members to include 3 neutral arbiters. So that's where we're at now, about changing and expanding the composition of the hearing panel. The floor is open for discussion. Jim, unmute yourself.
Chairman, I'd like to make a motion to accept the latter, which is the 5 and 3 neutrals, as you stated. I'd like to make that motion.
So is there a second? Is there a second to Mr. Vincent's motion?
Seconded.
Properly moved and seconded. Any questions about changing or expanding the composition of the hearing panel? Yes, Mr. President. Unmute yourself, please.
Unmute yourself.
Could you please repeat the motion again?
It was from the Rhode Island League of Cities and Towns recommends expanding the composition of the hearing panel to 5 members to include 3 neutral arbiters. So the motion was made to accept that second one.
Thank you.
Yes, Mr. Capezza.
I was wondering, are we having discussion on it now?
Yes.
Okay. I just wanted to say that I would oppose that, but what I would be in favor of is what one of the items that Sid Waddell had mentioned, was keep the panel as is and have those that are going to serve as neutrals attend training courses that prepare them to be a neutral. That was one of the things he mentioned in his testimony.
Yes, and if I remember correctly, there was something mentioned, and I forgot at which point, that there'd be a panel that it would be statewide, a statewide panel. That way, if people that were trained, it would be consistent. Whatever takes place there, it would be consistent statewide. And I do remember something along those lines. And if someone can build on that, and then that way we could have a good panel instead of having to pick one every time something happens in some city or town across the state. So, yes, Chief.
Yes, Mr. Chairman, that was brought up, and I think it's vitally important that that training did occur for anyone who is chosen to be a permanent member, whether it's expanded to 5, and that was the main reason why the police chief supported it, having a background in law enforcement, because you'd have that experience in dealing with discipline cases. So I think either way, the training is going to be integral to a panel that's named going forward.
Yes, Mr. Chairman, I'm not against training. I'm talking more about having 5 people and 3 neutrals. To the fact that they should be trained, that's fine. But that's my motion. I think it's been properly seconded. So, I have no objection to training, given that format.
Senator, you're on mute.
You can hear me now, right? All right. Chair, I just have one question. Again, not so much 5 or 3, but I am for 3 and 3 neutrals. But as we all know, who's going to have the overall authority to appoint these? I think we should know that also. That weighs in on a lot. Who has the oversight to appoint?
Yes, Mr. LEOBoR.
I was just going to ask a clarifying question, which is, I know the motion on the floor is in support of the Rhode Island League of Cities and Towns recommendation of a hearing panel of 5 with 3 neutrals. But I guess I would ask Jim, does that motion incorporate the remainder of the Rhode Island League of Cities and Towns recommendation, which was that they recommended that the 3 members be a standing committee to limit the ad hoc nature of proceedings and help form a precedent? Are you recommending that as well, Jim? Is that?
I'm recommending that as well. In discussions previously, there was a talk of the Superior Court Chief Judge maybe making that decision. I'm not quite sure if that was in their recommendation, but I think they even outlined who would make those recommendations. But yes, I do support that the ad hoc and the rest of this what you just stated as part of my motion. Thank you.
And the only thing that I would add is that I support certainly the addition of 3 neutral individuals. I do not believe that they have to be confined to individuals with a law enforcement background. I believe that then basically eliminates the possibility of any community members serving on this panel with
my motion is that that's not even required. The background. So yes, I'm not requiring that either in the neutrals.
Senator Coyne and then Mr. Barry.
I hope before we take a roll call vote that we have a clarification as to what this motion is. There's been a lot of discussion about adding this and adding that, and yes, this and no that. So before we take the vote, if we could have a clarification on what that motion is, I'd appreciate it.
And Mr. Barry.
I was Kevin Barry, in for Colonel Maney. I was actually trying to vote telephonically on the other 2 motions as well, but Senator Coyne just, that's exactly what I was going to ask the same question.
All right, well. The recommendation said the League of Cities and Towns recommends expanding the composition of the hearing panel to 5 members to include 3 neutral operatives, and then the language that Mr. LEOBoR said about the standing committee. So Mike, just finish that in for me again, will you please?
Sure, I'm reading from the recommendations that were handed out by Jake. And what it says is the Rhode Island League of Cities and Towns recommends expanding the hearing panel to 5 members to increase the number of neutral members. The working group also recommended that 3 members be a standing committee to limit the ad hoc nature of proceedings and help form a precedent. This would lead to a hybrid model where there are appointed members who serve a term and 2 members appointed by the charging agency and defending officer. That's the Rhode Island League of Cities and Towns recommendation in its entirety, which was presented on the list of recommendations here.
Okay, so the motion, and I can be corrected, but the motion is to expand the panel from 3 to 5 members to include 3 neutral arbiters and to have a standing committee. I just want to clarify the motion. Mr. Vincent, can you make the original motion that?
Yes, I made the motion, yes, and with the caveat that those neutrals do not have to be officers or former officers.
Mr. Chairman?
Yes, Chief Clements.
Just on the discussion as it relates to the motion, didn't also their recommendation include with the increase of 3 representatives to a standing committee for a total of 5? Under a new standing committee, the judiciary could appoint 3 permanent members, at least 2 of whom have a background in law enforcement and/or labor law. The 2 remaining members would be officers and management's representatives as provided for in the current law. Yeah, I just want to be clear before we vote. Wasn't that their written draft of the recommendation?
Yes, Jay? Yes. Jacob? Well, send the coin.
Thank you, Senator. I would like to include the comments made by Colonel Clements in the motion, please.
Okay, and Colonel, did you read from the recommendations that we put forth?
That was from the copies that I made on the written testimony from the leagues of cities and towns, correct?
Yes. Okay. So we'll do a motion to expand the panel from 5 to 3 members as recommended by the League of Cities and Towns. Can we do that instead of me putting the whole thing in there? How does that sound?
Yeah, to create a 5 members by the League of Cities and Towns, correct?
How's that?
Yes.
Yes, okay. Any further discussions? All in favor? Give me the thumbs up. So, Jay, give me the roll call. I'm sorry, excuse me.
All right, just to be clear, it appears that Mr. Vincent has rescinded his motion that was a verbal motion to adopt the Rhode Island League of Cities and Towns recommendation that there would be 3 neutral arbiters. In its place, Senator Metz made a recommendation that we accept the Rhode Island League of Cities and Towns recommendation regarding the hearing panel that would be comprised of 3 neutral arbiters. That is found in their written testimony. Senator Metz read that testimony into the record. And on a roll call vote, Senator Metz.
Yes.
Senator Metz votes yes. Senator Coyne.
Yes.
Senator Coyne votes yes. Senator Rogers.
Yes.
Senator Rogers votes yes. Attorney General Nerona. Attorney General Nerona votes yes. Lieutenant Colonel Barry, are you the designee for the Rhode Island State Police?
I am, yes, and that'll be a yes.
That will be a yes from Lieutenant Colonel Barry. Colonel Clements.
Yes.
Colonel Clements votes yes. Mr. LEOBoR. Mr. LEOBoR, I can't hear you, sorry.
I'm going to abstain only to the extent that it's not clear to me that we've resolved the issue of civilian involvement.
Okay. Mr. Vincent?
Yes.
Mr. Vincent votes yes. Mr. Capezza?
No.
Mr. Capezza votes no. Ms. Bettenker? Ms. Bettenker is absent. Ms. Swearingen? Is that a yes, Elise?
Yes.
Ms. Swearingen votes yes. Reverend Jenkins? Reverend Jenkins is absent. Reverend Washington?
Yes.
Reverend Washington votes yes. Senator, you have 8 in the affirmative, 1 abstention, and 1 no. The motion carries.
Yes, thank you. The next recommendation is amending LEOBoR's prohibition on public statements. The Rhode Island Police Chiefs Association and the Rhode Island League of Cities and Towns both underscore the need for greater transparency and discretion when an officer is under investigation. In a written letter provided to the committee, that was in a written letter provided to the committee. The second point under this one is in written correspondence. The IBPO also supported granting police chiefs more flexibility in discussing pending disciplinary investigation and charges. The next was Mr. Ragosta suggested adopting the balancing framework proposed in House Bill 8036. If recommended, discipline is less than termination, the law enforcement agency shall make no public statement until after a decision is rendered by the hearing committee. And with that, if recommended discipline is termination, the law enforcement agency may make a limited public statement indicating that the officer's termination is sought, that a hearing committee will be decided whether such is deserved, and whether and what, if any, criminal charges have been brought against the officer, and that the officer has or has not been suspended. After the hearing committee has decided the charges against the officer, the law enforcement agency may make additional public statements disclosing the charges of the hearing committee decision, and it may also release the hearing committee's discussion. In either of the above scenarios, if a law enforcement officer makes a public statement about the charges against them, then the law enforcement agency may respond with public statements of its own. So that was amending LEOBoR's prohibition against public statements. The floor is open for discussion.
Mr. Chair, I'd like to make a motion that statement that was made by you.
Okay, is there a second? Well, let me go through that again, because Mr. Ragusta had his testimony was a little bit lengthy. Again, the first bullet point under number 3, amending LEOBoR's prohibition on public statements. The Rhode Island Police Chiefs Association and the Rhode Island League of Cities and Towns both underscore the need for greater transparency and discretion when an officer is under investigation in a written letter provided to the committee. The next bullet, a written correspondence. The IBPO also supported granting police chiefs more flexibility in discussing the pending disciplinary investigations and charges. Mr. Ragusta, next bullet, Mr. Ragusta suggested adopting a balancing framework proposed in House Bill 8036. If recommended discipline is less than termination, the law enforcement agency shall make no public statement until after the decision is rendered by the hearing committee. And under that, if recommended discipline is termination, the law enforcement agency may make a limited public statement indicating that the officer's termination is sought, that a hearing committee will decide whether such is deserved, whether and what, if any, criminal charges have been brought against the officer, and that officer has and has not been suspended. After the hearing committee has decided the charges against the officer, the law enforcement agency may make additional public statements disclosing the charges in hearing committee decision, and it may also release a hearing committee discussion. And the final point under that is, in either of the above scenarios, if a law enforcement officer makes a public statement about the charges against them, then the law enforcement agency may respond with public statements of its own. So that's how that goes.
My motion is to accept Costa's recommendation as supported by the League of Cities and Towns and the Police Chiefs Association. And as you have stated, that body of would be my motion to accept
that motion.
Motion made and seconded by Chief Clements. Any discussion? Yes, Mr. Capezza.
The biggest problem that we hear from police chiefs, and this is usually reported by the news, is not so much on the criminal charges, because under the current Bill of Rights, anything criminal, they can make a statement. It has to do with departmental charges, and we would be in favor. Well, there's a motion on the floor, so I don't know. Yeah.
I think I know where you're going, but I think Alto Agasta's clarification covers that in bullet point 2 or bullet point 1.
Any further discussion? Any further discussion? If not, we'll take the vote. Jake, if you could take the roll.
Motion made by Mr. Vincent and seconded by Colonel Clements, I believe. Is that right, Colonel?
That's correct.
All right. Senator Metz?
Yes.
Senator Metz votes yes. Senator Coyne?
Yes.
Senator Coyne votes yes. Senator Rogers?
Yes.
Senator Rogers votes yes. Attorney General Nerona?
Yes.
Attorney General Nerona votes yes. Lieutenant Colonel Barry?
Yes.
Lieutenant Colonel Barry votes yes. Colonel Clements?
Yes.
Colonel Clements votes yes. Mr. Abora?
Yes.
Mr. Abora votes yes. Mr. Vincent?
yes.
Mr. Vincent votes yes. Mr. Capezza?
No.
Mr. Capezza votes no. Ms. Bettencourt? Ms. Bettencourt is absent. Ms. Swearingen?
Yes.
Ms. Swearingen votes yes. Reverend Jenkins? Reverend Jenkins is absent. Reverend Washington?
Yes.
Reverend Washington votes yes. Senator, you have 10 yeas, 1 no, and 2 absent. The motion carries.
Okay, number 4 of the recommendations that we had, I believe it was Mr. Bautista at the time, was repealing LEOBoR statutory framework in its entirety. Any discussion? If not, Jay, call the roll.
Yeah, I'm sorry. Yeah.
There's no motion on the floor.
Oh, right.
Oh, I'm sorry, excuse me. I'm getting ahead of myself. Who's going to make the motion? And
I'll make the motion for the sake of procedure. I make a motion, just on my council in the affirmative, as stated, to repeal the LEOBoR statutory framework in its entirety.
all right, is there a second?
I second.
Second by Mr. Vora. All right, the floor is open for discussion. If not, we'll,
Mr. Bohr, you're still on mute.
Ms. Swearengin? I'm sorry, excuse me. Any further?
Ms. Swearengin can go. She had her hand up before me, and then I'd like to speak.
Okay.
No, I was trying to get his attention for you, Mr. LEOBoR.
Oh, okay, thank you. Thank you.
Okay, go ahead.
Sure, yeah, my perspective on this is, you know, we've been meeting since July of this year, and no one has managed. We've had a lot of thoughtful presentations and a lot of thoughtful commentary, but no one has managed to convince me why there is a need for a law enforcement officer's Bill of Rights in Rhode Island when 19 out of 50 states have some version of this, which means 31 states do not. There hasn't been any evidence presented to this task force to suggest that things are awry in those 31 states that do not have a LEOBoR. And in all honesty, for me, I'm not sure I see why law enforcement officers should be treated any differently than any other municipal or state employee when it comes to due process rights. They are guaranteed by statute and by constitution. And there is no firefighter officer's Bill of Rights. There's no city clerk's Bill of Rights. I have not been convinced that there is even a need for this, which is not to say, and I don't want to be misconstrued, it's not to say that I don't believe law enforcement officers are entitled to due process. They absolutely are. I just don't see a need to have it codified separately from that which is guaranteed to every other municipal or state employee. That's my comment.
Further discussion? Mr. Capetta, Tony.
I agree with Mr. LEOBoR that police officers shouldn't be treated differently, but they are treated differently. On any investigation that's being done by any other citizen, whether it be a municipal employee, a private sector employee, or just the average citizen under investigation, has the right to ask questions. Police officers don't have that right. They are mandated to answer questions during the investigation, and if they refuse to answer them, then they would face further charges. As far as a need for a Bill of Rights, as Mr. LEOBoR noted, Rhode Island is not the only state that has a Bill of Rights. And the purpose of it is to make sure that they get fair treatment under the statute. This whole thing came about many years ago when police officers could just be suspended for no reason if the chief didn't like them. There's no other profession that can happen in. Private industry, it doesn't happen. You know, police officers, if they didn't have the protection, what would happen to them is that they could commit a minor infraction. They are suspended for it. If I was a construction worker or any other type of employee, I could commit a minor infraction and it wouldn't affect my employment at all. Police officers are treated differently than the average citizen. We don't have as many rights as they do, and that's why we have a Bill of Rights in this state.
Yes, Senator Rogers, then Chief Clements.
As an acting volunteer firefighter for over 40 years and an EMT cardiac, I hear the words, you know, there's no other profession that has oversight like the police department, but it may not be the exact type of oversight, but there are other professions, like my cardiac license. When I'm tending care to somebody, there is oversight for mistreatment and me revoking my license and possibly civilly be sued. So it's not unique to the police department. It may be molded a little bit different, but there are protections and oversight in many different fields. So I just wanted to put that in there because I've had to deal with the Department of Health sometimes on complaints and so forth. So just wanted to add that.
Okay. Chief Clements and then Mr. Vincent.
Yeah, Mr. Chairman, so certainly it is a unique profession by the work we're tasked with doing. It is a difficult profession, and a lot of the work that we become involved in becomes very complicated. And there are other professions that have that oversight, as the senator alludes to, with the medical profession, the legal profession. The original legislative intent enacted, or the intent prior to enactment, was to balance the constitutional process right, due process rights, with management rights and transparency. I think it's done that. I think it's right to change at this moment. That's what we're doing. I think we're speaking about some of the nuances of the bill that have changed, I believe, a couple of times. But to repeal, I am opposed completely.
Senator Metz, if I could jump in here, you know, I just want to try to bring some perspective from my federal service. I mean, the reality is that in the federal civil service, you know, it is, and I think properly so, that to take a job action against a federal employee is very difficult. And it's why I alluded to it earlier when I mentioned the 14 days. And to me, whether it's 10 days or 14 days, you know, it doesn't really matter. The point is to give chiefs more flexibility to address disciplinary issues they have. The point is to remove someone from the federal service. It doesn't matter whether you're a federal law enforcement agent. You could have been someone working on my IT staff or one of my lawyers. Was incredibly difficult. And that's why if you were going to suspend somebody for more than 14 days and you had to go to the Merit Service Protection Board, they just said go ahead and fire them, basically, because you might as well do it at that point. So, you know, so I guess to Mr. LEOBoR's point, I think that if we were to consider a major overhaul of this statute, it's very difficult to do that once every couple of weeks over 3 months. I think that's something that frankly requires more work and more time and more thought and more input. I think what I at least am hoping to accomplish here is tweaking the statute to give more transparency to the outcomes, to provide chiefs more flexibility to achieve the ends that they're hamstrung from doing it right now. And I understand that because it intersects with the criminal justice system as I do it. And when it comes to the panel, try to bring more voices to the table. Those things, I think, may not make the system perfect, but I think they will improve them. And I think that's the most I think we can accomplish in this format. So that's why when this comes up for a vote, I guess I'm presaging the way I will vote. But that's why it's almost as if we should have had this as our very first recommendation. Because had we had it up front and voted on it, we may not have needed to vote on the others. But that's sort of my perspective on this particular issue. So thank you.
Yes, Mr. Vincent and then Senator Rogers. Unmute yourself, Jim.
I think Senator Coyne was wanting to be recognized.
Oh, okay. Yeah, Jim, you got to unmute yourself.
I unmuted myself. Okay. My comment was that, yeah, I agree with Mr. LEOBoR. You have 30 states that don't even have it. And my comment also is that I get calls every day from employees who get disciplined for little, if not anything, primarily because they might be a woman or they might be a person of color. So I don't agree that, you know, that people do not get unfairly disciplined. They get disciplined every day, unfairly, for nothing sometimes. So no, every profession has people like that. So I am inclined to support Mr. LEOBoR because 31 states is the majority of states in this country. And like he said, it doesn't seem like the sky is falling.
Okay, Senator Coyne, and then we'll go back to Mr. LEOBoR.
Thank you. Just to expound upon a little bit what our Attorney General had said, we put a lot of work and effort this summer and this fall trying to make the statute much better, much fairer, and it would be a shame to suggest or to pass repealing the statutory framework. So I think by our hard work and our dedication over the last several months, we are making it better. Thank you.
Mr. LEOBoR, did you have some further comments?
No, I didn't, but just in response to what Senator Rogers said, I'm all in favor of making it better. Absolutely. I recognize that the motion that's on the floor is an extreme one. It certainly doesn't mean that if the motion doesn't pass, I won't utilize my voice to help, in other ways with all the other recommendations we have. I think sometimes, critical times call for critical measures. That's all.
So we did have a motion on the floor, and so we'll move forward with the roll call on the vote. Jay?
Motion made by Senator Rogers to repeal LEOBoR framework in its entirety, seconded by Mr. LEOBoR. This time I'll call the roll. Senator Metz.
Yes, trying to bring balance pretty much along the lines of what the Attorney General Nerona said. My goal in all of this was to bring balance to the system because I felt it was out of kilter. And with it being out of kilter, it wasn't helping matters because we've always tried to improve police-community relations. And that's why I always supported the community policing. With that said, the work that we put in so far and listening to people and hearing both sides, the good and the bad, the good, the bad, the ugly, hearing all of that, I think we did make good progress with these recommendations to make the system better. To make the system better, because we need both sides working together in the community to make things, really to make things better. And so, the honesty, that was important for me, the balance, credibility, and bringing and having trust. Because the only way we're going to make things better, especially in this current climate, in this culture, is people are going to have to work together. And with that, we put in a lot of work, as Senator Coyne said, and so I'll be voting no.
Senator votes no on a full repeal. Senator Coyne.
No.
Senator Coyne votes no. Senator Rogers.
No.
Senator Rogers votes no. Attorney General Nerona.
No.
Attorney General Nerona votes no. Lieutenant Colonel Barry.
No.
Lieutenant Colonel Barry votes no. Colonel Clements.
No.
Colonel Clements votes no. Mr. LEOBoR.
Yes.
Mr. LEOBoR votes yes. Mr. Vincent.
Yes.
Mr. Vincent votes yes. Mr. Capezza.
No.
Mr. Capezza votes no. Ms. Bettenker. Ms. Bettenker is absent. Ms. Swearingen.
Yes.
Ms. Swearingen votes yes. Reverend Jenkins. Reverend Jenkins is absent. Reverend Washington.
Yes.
Reverend Washington votes yes. Senator, on a vote of 7-4 with 2 absent, the motion fails.
Yeah, moving along, the next recommendation is maintaining the current LEOBoR statutory framework.
I will
Yes, Senator Rogers.
I will make a motion followed up by discussion to, in the sake of moving things along, to make a motion to maintain the current LEOBoR statutory framework.
Is there a second?
Second.
Mr. Capezza, okay, it's probably moved to second. Is there a discussion on number 5, maintaining the current LEOBoR statutory framework? Mr. Vincent.
I just don't know, what does that mean? Maintain the current, what do we, I'm not quite sure if I know what that means.
Well, whatever we have on the books now, just maintaining it.
So just to clarify, because I did make the motion for the sake of addressing this, again, I come back to my municipal leadership and addressing things on the agenda. the way I read it and the way I understand the reason why I made the motion, again, like was mentioned earlier, these probably should have been put at the top. So if this passes, I believe the things that we've added to the top will be rescinded. So I will be voting, when we get to that, no on this, because it will undo, the way I read the agenda and the motion, undo the 14 days and the other things that we've approved already. So I just want to clarify that that's why I made the motion and that's how I will be voting.
Yes, any further discussions? Any further discussion? If not, Jay, can you call the roll?
To be clear, that, I think that would be the understanding of the motion. There were several groups that testified that, for the possibility of no changes, and that's what that was intended to mean. So on a motion made by Senator Rogers, has been properly moved and seconded, to make no changes to this statutory framework, to law enforcement officers' Bill of Rights. Senator Metz?
No.
Senator Metz votes no. Senator Coyne?
No.
Senator Coyne votes no. Senator Rogers?
No.
Senator Rogers votes no. Attorney General Nerona?
No.
Attorney General Nerona votes no. Lieutenant Colonel Barry?
No.
Lieutenant Colonel Barry votes no. Colonel Clements?
No.
Colonel Clements votes no. Mr. LEOBoR?
No.
Mr. LEOBoR votes no. Mr. Vincent?
No.
Mr. Vincent votes no. Mr. Capezza?
No.
Mr. Capezza votes no. Ms. Battenker? Ms. Battenker is absent. Ms. Swearingen?
No.
Ms. Swearingen votes no. Reverend Jenkins? Reverend Jenkins is absent. Reverend Washington? I believe Reverend Washington is no longer on the call. Senator, on a vote of 10 noes, 0 yeas, and 3 absent, the motion fails.
Okay. Let me see. Yes, and those were the recommendations, 1 through 5, that had to deal specifically with the resolution that created this task force. Additional recommendations presented to the task force, not directly related to LEOBoR's statutory framework. I'm going to go through them. Annual data reporting regarding officer discipline and LEOBoR proceedings. That was one of the recommendations. The annual data reporting regarding officer discipline and LEOBoR proceedings. Any, you just want me to read through them, or what's your pleasure? Well, if anybody has any discussion or opposition, just let me know. I'm just going to go through them. Continued funding for collection of traffic stop data by the Department of Transportation, because I got wind that it's getting ready to end, and I think it has to do with funding. So we certainly want the funding for that, the traffic stop data, to continue. Require and support increased funding for continuous professional development and prejudice and bias training for law enforcement agencies and officers. Amending the Access to Public Records Act, APRA, to allow for increased disclosure related to law enforcement officers' personnel records. Additionally, some groups have expressed concern with officer disciplinary records being sealed and or expunged. Instead, they would like law enforcement agencies to retain all records of an officer's disciplinary history to ensure progressive discipline and accountability, and support the adoption of a statewide standardized process for collecting and maintaining information relative to officer misconduct. Yes, Senator Coyne.
Because these are outside the scope of LEOBoR, perhaps these recommendations could be included in the final report.
Yes, that sounds That's good input, Senator. Thank you. Any further ideas along those lines? Mr. Capezza.
Question. The first one, annual data reporting regarding officer discipline and LEOBoR proceedings. That's wide open. Like, who would actually collect it, and where would it be kept?
Well, that is a good question. I think. Go ahead, Senator Rogers.
I'd just like to add on to that. I think all of these need more in-depth discussions. I'm not for or against any of them, but they have to be drilled down to the weeds. Like, for example, the second one, which I agree with, professional development and continuing training. But again, unfunded mandate, if you require the cities and towns to absorb this, it's just another unfunded mandate that gets pushed down to the local taxpayers. So a lot of this, I believe, has to be vetted out. So I think they're just general at this point. We really shouldn't get into any further than just added to them. If any of them's going to go.
Yes. Anyone else? Mr. Vincent.
Yes, I would agree with the coin that things would be included with the report.
Yeah, that's fine. Do we have consensus on that they be included in the report?
Senator, if I could ask, included, and forgive me for not fully understanding, so they would be included in the report as recommendations of others that were brought before the committee, but that the committee did not act upon? Is that how they would be included in the report?
Well, we could. It was recommendations received that don't directly relate to LEOBoR statutory framework. I think that would be the clarification. So these are other things that we received from the the people that testify from the community at large.
Understood. But we're not taking a position on them, I assume, because we're not discussing them and we're not voting on them.
Senator, what I can do is I can detail in the report who made those recommendations. And I'll circulate a draft.
And that's all. We're just going to list them. We're not going to go into any detail.
Thank you, Senator.
Okay, with that, I think we need one more meeting next week. Is that fine for everyone? That's fine, and so next week, and hopefully we can.
Wait, I'm confused. Isn't there a motion on the table?
No, there was no motion.
There was no motion ever made?
Yeah. Well, if you think we need a motion, maybe we should. It's just that we're going to include. A motion was made to include these other recommendations in the report.
So a motion was made?
No, it wasn't. We didn't make. That was the consensus, but we didn't make the motion.
Senator Metz, I'll make that motion.
So moved and seconded by Senator Rogers and Mr. LEOBoR. All in favor?
Aye.
Aye, and there's no one opposed, so there's someone opposed, let us know, so it's a unanimous, Jay. That we include these other recommendations in the report. And with that, thank you so much for your time. We'll meet next week to finally bring some closure to this. And with that, I just need a motion to adjourn.
Lieutenant Colonel Bailey, did you have a comment?
Yeah, who wants that? Who has the comment?
Mr. Chairman, it's Kevin Barry. I just, if I could, I know everybody's pressed for time. I just wanted to vote. I was trying to vote when you were voting on the reduction of days or the increase in days from the 30 to the 14 to the 10. So is there a possibility of just a revote so that I could just weigh in on that as well? I was trying to vote. My vote wasn't coming through.
Lieutenant Colonel Barry, if I may, how would you have voted?
So I would have voted for the 10-day.
And we did have a vote on 14 days. What?
And I would have voted no on the 14 and no on the 30.
Okay, those votes have been recorded and they do not affect the outcome. The vote of 14 days carried by a vote of 6-4.
Okay, so we'll let you, we'll include your vote, Mr. Bannon.
Thank you, Mr. Chairman.
Adjournment, Mr. Chair.
The motion to adjourn by Mr. Vincent, is there a second?
Second.
Senator Rogers seconded, all in favor say aye.
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 So thank you all, and we'll see you next week, and thank you so much for your participation. Appreciate you.
Thank you, Chairman.